Welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back to the next episode of Arbitration Acumen, in which we'll discuss the Saudi Center for Commercial Arbitration, colloquially known as the SCCA, with Chris Alberti, who's the SCCA Chief of ADR and General Counsel. I'm JP Duffy. I'm an international arbitration partner at Bracewell based in New York that acts as both counsel and arbitrator in international arbitration seated around the world under a variety of governing laws and arbitral rules. I'm qualified in New York, England, and Wales, and the DIFC courts in Dubai, and I previously lived and practiced in the GCC. I also routinely represent clients in arbitrations involving Saudi, and I have the good fortune to be listed on the SCCA arbitrator roster, which I've been on since 2019. So as I mentioned, with us today is a great guest who I've had on in the past when in previous iterations of this podcast. Chris is the Chief of ADR and General Counsel for the SCCA and is based in Riyadh, where he supervises the SCCA's Case Management Secretariat and Legal Department. Prior to joining the SCCA in 2019, he was the Assistant Vice President of the ICDR in New York, where he supervised staff and related management activities and oversaw hundreds of large, complex multi-party arbitrations and mediations covering all types of disputes and industries each year. While in New York, Chris also taught international arbitration and international sales law as an adjunct professor at the NYU School of Law. And prior to joining the ICDR in 2005, Chris headed the Italian desk of a mid-sized law firm in Germany. Chris is a fellow of the Chartered Institute of Arbitrators. Chris and I actually did our fellowship certification together in New York, I think back in 2019. He's a member of several ADR organizations and is certified to practice law in Germany and in New York. So we have a great source of knowledge about the SCCA and the Saudi market today with Chris. So welcome, Chris. Thank you for joining again.
Hey, JP. Great pleasure to be with you today.
Well, good. Before we jump into some of the more substantive questions we have, let me start with a little bit of background about the SCCA for those listeners around the world who are not as familiar with it. The SCCA is a not-for-profit organization that was set up by royal decree in 2014 as part of the kingdom's 2030 vision, which is a government program that seeks to diversify Saudi's economy to make it the heart of the Arab and Islamic world. The SCCA became operational in 2016 and provides both arbitration and mediation services with the stated objective of becoming the preferred ADR provider in the region by 2030. We're going to talk about this more with Chris, but in 2023, new SCCA rules came into effect, and particularly, we're going to discuss how they align with global best practices. Now, one of the key features of the rules was the creation of an independent SCCA court that was created for the purpose of making key administrative and procedural decisions in SCCA-administered arbitrations, such as deciding consolidation issues, arbitrator appointments, arbitrator challenges, and critically reviewing arbitration awards, which is a really important function. The SCCA court is currently comprised of 23 members after having added 8 new members in July of this year to account for the increasing workload that they have. They hail from 16 countries, with members serving for 3-year terms that can be renewed once for a total of 6 years on the court. So as you can see, the SCCA under Chris's direction has been incredibly active, and we're really fortunate to have him here today to educate us about the SCCA's future plans. So with that, let's turn to Chris, because we've heard enough from me. And let me ask you a few questions, Chris, just basic things about the SCCA, and then we'll dive into some of the rule changes and some more substantive matters. But for those that are less familiar, does the KSA government play any role in running the SCCA?
No, not at all. It just happens to be established by a royal decree. Government was very clear at the outset that if the SCCA wanted to succeed, it would have to be an independent, neutral, not-for-profit organization. I guess this is best showcased by the SCCA board of directors operating fully autonomously and free of any internal or external influences. In a sense, arbitration is protected by one, but two Chinese walls, if you will. The first one is really between government and the board itself, in that no board member can hold public office while also sitting on the SCCA board. And we became victim of that actually twice, in that we lost a board member just because of this very strict rule in our statutes. And you will find the second wall between the board and the secretariat, in that the board has now the knowledge of any specific cases, nor any form of influence over the case administration. And both these walls are very important to build trust in our services as a neutral and fair ADR provider. It, of course, helps tremendously to have an amazing, diversified international board of directors to safeguard SCCA's strategic alignment with global best practices. And I should also say that we're very blessed in good hands with Dr. Walid Abanumay as chair and Tommy Landau, KC, as vice chair.
That's great. That's really great. And, that gives a lot of comfort, I think, to people around the world that when they choose SCCA as their administrator, they're getting a truly independent body. Now, we've discussed this in the past, but what role did the ICDR play in helping to set up the SCCA?
I was sure you're going to ask this again. So I worked for the AAA ICDR in the past, but just to reiterate where this all started in 2014. So the role of the AAA ICDR was indeed a vital role for the success story of SCCA, in particular the first 2 years, if you will. And we're very grateful for all the help and support we have received. It really started with setting up robust governance and infrastructure. You have to think about cooperation on drafting rules, procedures, code of ethics, all these things that you need for an institution. And then, of course, training staff on site in New York. So all that happened in the first 2 years. So this really enabled the SCCA to hit the ground running in 2016 when we actually became operational and were able to focus our energy on client service and growth rather than dealing with all the unfortunate mistakes young institutions typically would do in the first years.
Interesting. Well, that's great. And that's a really good level of support to have had. Now, what's the role of the SCCA Global Advisory Committee?
The Global Advisory Committee is headed by Richard Neymark, and to be former Senior Vice President of the AAA ICDR, and is currently composed of 16 distinguished arbitration experts with 11 nationalities from around the globe, so it's very international. The committee basically provides technical advice. It monitors international arbitration trends, best practices, evolving best practices, and introduces also innovative services. Perhaps most notably, it provided vital support in reviewing and drafting the 2023 arbitration rules you mentioned earlier. And perhaps also very interesting to hear is we're working right now on the revision of the SCCA mediation rules, as well as the tribunal secretary relations, and also the ODR procedure rules, which is Appendix 4 to our rules, perhaps soon also called fast-track arbitration rules. So very busy committee right now. And all these 3 texts will be launched early next year.
Wow, that's quite quite a role to be playing.
It's a handful.
Exactly. Chris, one of the things that's unique or interesting about the SCCA is its caseload. And we're going to dive into that more in a bit. But before we do, does the SCCA administer both domestic and international cases?
Yes, we do. I know that we will talk more about numbers later. So let me just say that particularly the last 3 years, we have seen a significant increase in disputes with an international nexus and the language of arbitration being English. So far, parties in SCCA cases since launch came from close to 30 different nationalities, in fact.
Great. Well, Chris, before we dive into that caseload more, and I think that's going to be a really interesting discussion, just maybe give the audience a little bit about how the SCCA is aligning itself with the Kingdom's 2030 vision, which is a really important initiative that's leading to a lot of interesting changes in the Kingdom.
Look, if you want to achieve economic diversification, you will need to rely on some extent on foreign investment to promote economic growth, but also development. And whether that is FDI or FPI doesn't really matter. The point is that you need to think at government level how to create a comprehensive ecosystem that allows an investor to protect its investment and fight it out, quite frankly, in an adversarial process if need be. This is basically where the SCCA comes into play and why it is important for us to make these international appearances, to go to many cities and present the SCCA as an institution. And you will need to build trust in Saudi seat arbitration at some point with full international reach under the New York Convention. You need to also build capacity on arbitrators, practitioners, judges, but also invest in the next generation, today's students, for example. You also need to ensure that the court system supports arbitration without undue interference. And finally, you need government support. You need to have someone pushing all the right buttons. And as you know, a newly revised arbitration law is to be released shortly, and almost all pain points have been addressed. And so the SCCA plays a very pivotal role in all these different endeavors, perhaps not the classical or typical job description of an ADR institution, but this is our small contribution to making Vision 2030 a success. And of course, grab some cases along the way.
That's right. A few cases that you guys are getting. When I'm laughing, I'm saying that obviously sarcastically because the growth has been very, very impressive. And we're going to talk about that in just a minute. But I just want to highlight one point that we're going to pick up as we go through this, which is that new arbitration law, which I think has been a very, very welcome development around the globe. Well, with that, let's talk a bit about the caseload because it's really increased markedly over the years. And if I'm not mistaken, the SCCA issued its 2024 annual report in April of this year, and that set forth a lot of those statistics. So let me start by asking, how many cases did the SCCA register in 2024?
So in 2024, the SCCA recorded 120 new filings. That is an increase of a little bit over 30% compared to the 92 filings in 2023. And perhaps I can also share, did some math before I joined you on this call today. I can already share that we exceeded last year's numbers of 220 filings in 2025, currently at 132 new registrations for 2025. So that's already roughly a 10% increase with another 2.5 months to go.
Wow, that is truly impressive growth. Now, how many of those new cases were arbitrations?
Again, in 2024, we saw 72 arbitrations. Again, comparing this to the previous year, we only had 46 arbitrations. So that's a hefty increase of almost 59%, almost 60%. And again, as we speak today, we already registered 95 arbitrations in 2025. And that's an increase of 30%. And again, we have another 2 months to go. So you can imagine that this led to quite a bit of adjustments within the Secretariat, obviously starting with scaling our case administration capabilities to accommodate this influx in arbitrations.
That is a really impressive increase. Now, are the balance of those cases, are those mediations? Is that what comprises the remainder?
Mediations plays a 10% role in the overall caseload at the moment. It's on the rise. We're trying very hard now with the new mediation rules and that release to really push those numbers, but it is still a side role. It's mostly arbitrations and then some limited services.
Wow. Okay, great. Well, congratulations on such an impressive increase. What was the total value of the new cases that were filed?
In 2024, I think we came in at 1.1 billion real. That equals to roughly $304 million. And again, before I joined you, I looked at the 2025 numbers as they stand right now. We more than doubled this number already, and we're north of 2.5 billion real, which translates to roughly $667 billion.
Wow. So a 200% increase in 2025 over 2024.
And counting.
Wow. Yeah. With a few months left to go in the year, that's very impressive, particularly since you do end up seeing, in my experience, at least more filings towards the end of the year as people decide they have to get things done. Very impressive. For the audience's benefit, what was the average time to resolve a case in 2024? And if you can share it, I guess maybe not in 2025, but certainly in 2024.
Yeah, so 2024, arbitrations were disposed of in less than 6 months on average, and that includes every form of arbitration, awarded, non-awarded, settled, withdrawn, etc. So, of course, we need to take a little deeper look at the numbers here and all the forms of terminations of arbitration. So what we do also, we look at arbitrations ending in an award, and these closed in 2024 on average in less than 7 months, with the longest taking just under 14 months. That said, again, looking at 25, we have a few large and complex cases in the pipeline right now, which will likely see the 2-year mark. So it's not all just very short in and out, but sometimes it takes also longer. But again, the main goal remains to get parties in and out of the dispute swiftly with fair and just results and ads. We do that mostly with the use of technology and proactive, but obviously never intrusive case management approaches. Now, so let me give you an example there. We will on average initiate a case within 2 days from the date of all filing requirements having been satisfied. And the so-called administrative conference call typically takes place within 10 days after commencement.
Wow. Okay. That is very, very impressive speed as well, which is really, really valuable to end users because they definitely do not want to spend their time dragging their feet in disputes because of delays with the administrator. So that is truly impressive. Now, one thing that I think people will be interested to know about is the number of cases that the SCCA is administering that are construction cases. I mean, obviously, that's always a large portion of any caseload internationally, but also I think in the region, there's this perception that that's what a lot of these disputes are about. So what percentage of the cases that the SCCA administered in 2024 were in the construction sector?
Perhaps to no surprise, construction and engineering, again, at the charts with 38 share in our caseload. And this has been fairly consistent around 30 to 40% over the past years.
Which makes a lot of sense. I mean, that's a huge sector of what's going on in the region. So certainly that's not surprising. Now, what industries do the remaining cases come from, though?
This is actually very interesting because that is something as a fairly young institution, you hope to achieve this market penetration. And that happens at some point. In SCCA's case, it has happened quite fast. In fact, we have increased last year again this amount of sectors, but having cases deriving from 13 different industry sectors. I should also add that we are taking and tracking up to 31 separate sectors to ensure that we can perfectly match suitable arbitrators on our roster with cases we administer. But to your question, in 2024, we saw, for example, professional services. We have seen cases in employment and labor. Capital markets and investment was large. Agriculture, food and beverages. Another area was commerce, e-commerce, trade and retail. Real estate, obviously, corporate has played a role. And this is just to mention a few. 2025, to give you an outlook, it jumped again to now already 17 different sectors. New sectors that we have seen that are on the rise, hospitality and tourism, which is probably not too surprising. The next one, I think, is down your aisle, life science and healthcare, manufacturing. We've seen media and marketing, shipping, logistics, maritime, and technology, and lastly, telecommunication.
Wow. Okay. That is very diverse, and that's great to hear because that is the mark of a truly maturing institution. Very, very good to hear. Now, let's shift gears a bit then and talk about the 2023 arbitration rules, because that was a really positive development. So as we discussed earlier, the second edition of the SCCA rules came into effect on May 1, 2023. So the SCCA has now had over 2 years of experience with those rules. What are some of the really salient features of those rules that the audience should know about?
I think the first thing that comes to mind is having very robust governance, and technology plays a key role here in our rules. I think the word technology or technological is mentioned at least 12 times in our rules. And it really starts with electronic submissions in Article 4 and Article 5, the request for arbitration and the answer thereto can be submitted electronically, typically done by email, but soon through our new platform. You can look at Article 25, subsection 2, which has a lot of language about encouragement to use technology, including electronic communications, e-filing, even presentation of electronic evidence. Next is Article 36, subsection 1, electronic signatures for awards. And then we have an entire Appendix 4 that is very technical. It's our ODR, or Online Dispute Resolution Procedure Rules. That's all run through an entire dedicated platform with everything online. And this applies to cases that do not exceed 200,000 real, which is roughly 53,000 US dollars. We do have expedited procedure rules, Appendix 2, that applies to cases that do not exceed 4 million. Here, perhaps a key factor is that the issuance of the award has to happen within 30 days of the closing of the proceedings, or 180 days from the appointment of the sole arbitrator, whichever event occurs first. Emergency arbitration, that is something you see now in every mature set of rules. Here we have to have the arbitrator appointed within the same day or within 24 hours. And the arbitrator plus emergency arbitrator has to issue the emergency interim award or order within 14 days of his or her appointment. So a very fast process. One part that we've been very eager to introduce in the 2023 rules was Section 2, a whole new section about multi-contract and multi-party arbitrations. You find those in Article 11 through 14. And just to very quickly give you a glimpse, Article 11 is about filing claims based on the multiple contracts or multiple arbitration agreements in a single request for arbitration, which helps a great deal when you have multiple claims under multiple contracts, which technically belong together in a sense. You have Article 12, which is all about the joinder. Article 13 talks about consolidation. And perhaps here it's worth highlighting that we add a language that addresses head-on all the DUTCO-related issues that sometimes happen in arbitrations. This has to do with the reconstitution of the arbitral tribunal by the SCCA court, and it also includes relocation of appointment of arbitrators. So that really protects the case and the parties. You have Article 14. This is about coordinating multiple proceedings when you have in both cases the same tribunal. Where appropriate, of course, you can align specific procedural aspects or issue even a single award. Fast forward, conduct of arbitration, and please, JP, stop me because I can speak all day about our rules, but the conduct of arbitration perhaps is another area that is of interest. If you want to have a case management conference as an arbitrator, it must be held within 30 days of the constitution of the tribunal. Tribunals are empowered, again, robust governance, empowered to exclude cumulative or irrelevant testimony or evidence. And tribunals are, and this is perhaps fairly unique, you see this rarely, are even able to remind parties of the benefits of mediation and very carefully question whether mediation should be entertained at some point in the arbitration without, of course, taking sides. Early disposition, Article 26, that is a provision that is always called something that has a double-sided sword. We made very good experience with early disposition. That is basically when the tribunal may dispose of issues of jurisdiction, admissibility, or legal merit raised in a claim or defense. For example, a claim or defense is manifestly without merit. That application must be filed within 30 days and has to be decided within 30 days. So very quick in and out to get rid of things that do not belong in the process to start with. Exchange of information, lots of limitations on submissions, limitations on oral testimony, witnesses, document production. Again, encouragement to use electronic means, and inspection of relevant premises or objects is also codified in Article 27. Briefly, hearings, Article 29, document-based unless the party requests otherwise and the tribunal deems it appropriate. So the tribunal has really the power to decide the mode and format of the hearing. It could be remote, which we see quite often happening actually in Saudi Arabia. And then you have also Article 36, very important. I mentioned this earlier, the effect and form of the award. It can be signed electronically, and we can publish redacted awards for a partner called Usemundi, which we have started now to publish the first awards on their platform to really get this more transparently out. I'll stop here, but there's much, much more to talk about.
Yeah, no, certainly. I mean, those are all really great developments. Let me unpack some of that, and let me start with expedited proceedings. I think you said it's 180 days from the appointment of the arbitrator, or 30 days from the closing of the hearings. Is that right?
That's correct.
Okay, and it was for matters under 4 million real.
Correct.
So that's really quick. Now, what percentage of cases are falling into the expedited proceedings by default?
It's currently a 50-50 cut. So we have ODR cases up to 200,000. These kind of are around 20%, I would say. The next 40% are expedited, and the last 40% are regular arbitrations under the regular arbitration rules, meaning above 4 million.
Wow. Okay. Great. One of the things we talked about under Article 7 was emergency arbitration, and I think you said that's got a 15-day time frame, which is relatively consistent with most emergency arbitration provisions around the globe. I did notice in the draft law, it looks like the definition of tribunal is going to be changed to include emergency arbitration or emergency arbitrators, which would be a really positive development, certainly on the enforcement front. What's your view on that?
This is an area that we've been very, very eager to explore. Also, when we were asked by government what we think should go into the new law, emergency arbitration is certainly one of those areas. Interim measures can already be enforced. We know that. But the question is always the one of finality when it comes to emergency awards or orders. Even the word order itself can sometimes cause trouble when people get stuck too much with nomenclature. So we see this as a very positive development that now, as it sounds, as it seems, we have to see this in action, that emergency awards are all the more likely to be enforced in Saudi Arabia.
Which is a really positive development. I mean, that's a challenge around the globe, but when you have a really strong developing economy that is doing big infrastructure projects and working on lots and lots of things that are happening very quickly, emergency arbitration is a truly valuable benefit. So that's great to hear as well. Now, one of the things that law, I think, is also looking at is the qualifications for arbitrators. And I'd just be interested in hearing you expand on that a bit, if you could, for the audience's benefit.
Absolutely. It's another area that causes concern today. Rarely, but it has happened. Article 14, as it stands today, says that a sole arbitrator or the presiding arbitrator, when it's 3 arbitrators, must have either a law degree or a degree in Sharia. Absent that causes issues. Can already give away that we have seen cases or case law where judges have said, well, it is an issue, you have probably breached that, but it's not a ground under Article 50.1 to set aside an award. But nonetheless, this always caused a headache, if you will. That now is gone in the new arbitration law as I know it. So it's a very welcome development. Now it seems to suggest that arbitrators do not have to be lawyers, do not have to have a Sharia degree, whether sole presiding arbitrator or any arbitrator for that matter.
That is definitely a positive development. I think anything that takes away possible enforcement defenses that could be concerning and that expands the pool of possible arbitrators is definitely a valuable addition. Now, one thing I would just like to have you expand on a bit too is the award review under Article 36(4). So I understand the SCCA court will review awards. That's usually a little bit of a mysterious process for people. So maybe you could just expand on that one a bit to the extent you can.
Absolutely. So the review is actually quite simple. Officially, it's a review as to the form. But we kept it quite vague in our rules to allow the SCCA court to speak up when obviously there is an issue of substance. And anything the court would recommend here is to review this particular section in the award. It will not make obviously orders of sorts that something has to be revised. It stays, in other words, with the arbitrator to decide ultimately what to do with these suggestions. But the way it works from a process perspective, we get the draft award from the arbitrator or arbitrators. We do a first cursory review. It's more than a cursory review. We actually look at this quite intensively. Once we are satisfied with the draft, we send it over to the SCCA court. There could be a single member committee, or it could be a committee of 3 members. That committee will look at the draft award, sends it back to us. We again cross-check and then send it over to the arbitrator. That all happens quite quickly. It sounds like a lengthy process, but on average, we do all that in a matter of 5 days.
Wow, 5 days. Okay, that is certainly impressive because review is a great process, and scrutinizing of the award is an important aspect of things. But I think sometimes users do get concerned about how it can hold up the ultimate award. So a 5-day review process is impressive.
Of course, if we have a 300-page award, I will take that back. But for the regular draft award, that's it, 5 days.
Got it. So you reserve your right to take more time if it's
always
needed, but
always.
That's great. Now let's talk a bit about, before we move to some other initiatives, and I really want to circle back too on the Jus Mundi point that you raised. But before we do that, let's just talk quickly about costs. Now, the SCCA has a cost calculator for estimating administrative and tribunal fees, if I'm correct. Let's talk about that a bit, and let's start with how arbitrators are compensated.
So no rocket science there for us. It is, like many other institutions, done with the default classical ad valorem approach, meaning we look at the sum in dispute, the aggregate amount in dispute, and the SCCA court then will fix the administrative fees of the SCCA as well as the arbitral fees per the fee schedule. And as you just mentioned, there's a fee calculator for that to make that easy. We have ranges. There's an average range, which is classically what will be chosen by the SCCA court for at least the advance deposit at the outset of the case. The SCCA court can go higher by up to 30% or lower by 30%. And that really depends on factors like complexity, or is it a straightforward case? Is it one or more parties? Is it multiple jurisdictions? Those factors may play a role. That all said, parties have the right to agree on an alternative fee arrangement based on an hourly rate. This is sometimes a good idea when you have larger cases where everyone wants to pay the arbitrators by the hour. So you have that flexibility to really make such agreements. Obviously, we will not allow for any lump sum retainers or success fees. All that is not allowed. It has to be really based on the hour.
Interesting. Okay. Interesting. Now, that raises a question for me too, just as we're talking about arbitrators. The SCCA obviously maintains a roster. You were kind enough to get me onto that in 2019. How many people are currently on that roster?
So we currently have around 600 arbitrators and mediators on the roster. Just to give you a quick overview, because I just checked the numbers before I joined you, we have around 50 nationalities, over 50 industry sectors, and arbitrators and mediators speak up to 30 languages. And if we cannot find an arbitrator for any specific case, because there are sometimes experience requests that are very unique, we have plenty of memoranda of understanding with other institutions, so we can obviously approach our partners, if you will, and ask for names if and when we run out of ammunition.
So the SCCA can go off its own roster if it needs to. Now, can parties as well select arbitrators that are not on the SCCA roster?
Yes, absolutely. Where parties either jointly nominate an arbitrator or where each side has to nominate its, let's say, wing arbitrator. They're not bound by the SCCA roster at all. You can use any source you like.
That's definitely an interesting point for people to keep in mind, that they have total party autonomy for the most part to select an arbitrator of their choosing, but it's also great to know that there's such a well-developed roster to help guide things. Chris, one of the things that's always impressed me about the work that you've done with SCCA and the work that SCCA itself has done are all the initiatives it's undertaken since its inception outside of, rule revisions, case administration, all the contributions it's made to the arbitration world. And one of the things that intrigued me about that is something you mentioned earlier, which is the Jus Mundi publication initiative. I'm on the publications committee of another institution that's working with Jus Mundi as well. So I'd be interested to hear more about that and what the SCCA is doing in that regard.
Yeah, it has been a wonderful cooperation for quite some time now. We started a while ago to explore areas where we can cooperate. I think most prominently, we are sharing Saudi judgments of interest for publication using Jus Mundi's AI capabilities. You may have heard about our case law studies that we have done in the past. Just this year, we finished our fourth study about Saudi case law of interest for 2023, deriving from the appeal courts. Here we basically pitched the human against the machine in that we have assembled a team of 20 people to look over 1,000 judgments. And at the same time, we used AI with our friends at Jus Mundi to do the same. And it was interesting to see that the human took 300 hours to do what AI was doing in a day or a day half. So quite a difference. And the results were astonishingly consistent. So it's really the path of the future for us to index judgments and a path forward for research and for Saudi judgments. Another area where we collaborate is now the publication of redacted awards. This is fairly new, and you will see hopefully soon the first SCCA awards being published on the Jus Mundi's platform. And that also goes then with the case data. We will, of course, not give away the party names, and certain other areas or aspects will be kept confidential. But we try to be as transparent as possible. For example, you will see the arbitrator who actually issued that award, or arbitrators, and other information that is otherwise not jeopardizing the identity of the parties themselves. So very interesting projects happening right now, and there are more things that we're exploring right now.
Interesting. Well, I think anything that helps give a bit more transparency to the award process is great, because that certainly is something that parties love. And it really does highlight, I think, as well for the institution, that the quality of the work product that's coming out of administered cases. Now, what are some other initiatives that you're undertaking? Because you're always doing so much. Let the audience know about all the things that you're doing and what the SCCA is doing beyond simply case administration, rule updates.
It has indeed been quite busy 2025, so I'll try to keep this as brief as possible, and otherwise, please cut in. So we have the SCCA Academy, which has been quite busy. The Academy itself is our education arm, if you will, and an offers a range of training programs that both come in two main forms: long-term programs like a fellowship or short courses usually organized in partnership with selected best-in-class international institutions in the ADR industry. For example, we're offering the International Fellowship in Commercial Arbitration in cooperation with the Chartered Institute of Arbitrators. I think we did 4 courses across all 3 modules with over 400 attendees in this year alone. We offer mediation courses, tribunal secretary workshops, negotiation skill workshops, and ADR cost drafting workshops. Another highlight, obviously, is Riyadh International Disputes Week. Cannot leave you without talking about that. We are now in the 3rd edition. The RADW, the International Week, will happen from the 1st through the 5th of February of 2026. Just for those who do not know, RADW, or Riyadh International Disputes Week, it's the largest legal gathering in the MENA region at this point, and one of the most influential on the global stage. Couple of numbers. The 2nd edition this year attracted 5,300 participants from over 80 countries, featured 471 speakers across 87 events. So it's quite a large event that has really attracted a lot of international attention. And we're very much looking forward to February of next year. So please join us, come over to Riyadh. Beautiful time anyway in terms of weather. We are very eager to push also the younger generation. We continue to do what we have started many years ago. I'm talking about the SCCA International Arabic Mood, or in short, SIAM. We're now in our 7th edition, and it grows really from year to year. It's very, very fascinating to see how this develops. The problem is drafted by a special committee. It uses the SCCA Arbitration Rules, of course. The substantive law is that of the CSG, so International Sales Law. And in many ways, it's similar to what you may know from the Bismuth. And it's designed for those students whose English capabilities are not that strong. So at least they have a platform where they can actually moot. And just to give you some numbers, the last edition, the 6th edition, showcased 924 students. That translates to 54 teams from 24 countries. And they were judged by 530 arbitrators. So it's really impressive. And the trend continues. All girl teams seem to win these competitions all the time. Other initiatives, we are obviously very engaged internationally with UNCITRAL. We're actually representing the kingdom at UNCITRAL Working Group 2. While we're independent, we have that honor to represent the kingdom there for many years now. We prepare reports and take very active role in the debates at New York and Vienna. And it is all currently about electronic awards, which is kind of the topic of the day at the moment. We have another interesting initiative that is still in its baby steps, but it's making great strides. It's called the RIAD initiative. The initiative seeks to recognize electronic awards, staying on the topic, issued by accredited arbitral institutions across member states to this initiative. So essentially what we're trying to do here is to eliminate the mandatory requirement for their ratification through, for example, embassies, ministries of foreign affairs, or apostille processes. So this will be achieved by establishing secure digital platform communication channels that directly connect the arbitral institution with the judicial authorities in the member states. So it's a very fascinating project, and we really hope this will take off at some point. In that same vein, another initiative we launched earlier this year, our digital signing capabilities that are in compliance with Saudi law. It's a white label platform where you really sign every SCCA award right now electronically. And we have done this for now many months. We have not sent an printout award for over a year, but this new feature will really allow us to make that bulletproof. And it's actually also enabling you to get e-signatures with a digital certificate. So it's a really full-on software that helps us now to take that next level to go full digital. We have another area where we will soon launch manual case management software. We've been working on this for probably 2 to 3 years to create a custom-made solution to streamline internal case management workflows. And the software is about to be ready. We're still testing the external platform for the users. And once all this is done, it will enable users to really file 24/7 cases online. You can exchange documents, manage documents, event management is part of it, obviously finances and so forth. So a lot of very cool things that will happen with the software to really, again, expedite the process.
That is very impressive. And all things that are clearly, certainly on the software front that you just managed, designed to make cases much more efficient and much more economical. And great to hear as well about the SCCA International Arabic Moot. Really, really wonderful to hear about engaging more students across a broader range of skill sets, which is really important. And certainly everyone, mark your calendars for Riyadh International Disputes Week, February 1st to the 5th in 2026. That is truly a huge, huge event at this point. Well, Chris, you have been incredibly generous with your time, and you've got a lot of things going on. So your generosity is even more appreciated. I think what we should do is wrap this up for now, but we're definitely going to have you back again in the future, because every time we have one of these discussions, there's something new and interesting to talk about that we haven't hit upon yet. And it sounds like with everything you're doing that there'll be plenty more to talk about in the future. So with that, let's conclude our discussion of the SCCA. I want to thank Chris Alberti for joining and for offering his invaluable insights. And I want to thank you, the audience, for listening. You should feel free to reach out to Bracewell about today's podcast with any questions you might have. And you should also feel free to reach out to Chris. I know he's a very accessible individual, and he'll be happy to answer any questions you might have. And we look forward to having you tune in for future episodes in the Arbitration Acumen series. So, Chris, thank you again, and we look forward to having you back in the future.
Thank you very much, JP, for having me.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.